Okay, very good. Well, so thank you so much. Special thanks to Sydney for reaching out to me a couple of weeks ago. This is probably a really great experience for you at this time. And thank you so much for Tierra for introducing us to the network, the Supportive Housing Network. I do see many organizations that I've worked for or with alongside in the past. So I'm happy to see you all here as well and the interest that you have. So I'm just going to briefly introduce myself, and then I'll have Maddie introduce herself, and then I'll start the presentation. So my name is Wendy Silva, and I'm an associate court attorney, and I've been working at the Surrogate Court since the end of November 2018, and I was hired to run the help center because there was a large need for assistance to be given to pro se litigants who were coming to the court who really did not know what surrogate court was or is. And so I was brought on to help the public and engage them in understanding what they need to file and what their role is. So generally what I do at the help center is meet with individuals and go over the forms to make sure that it passes the requirements for filing in our court and explain to them what their responsibility is. I don't represent the individuals, but I do guide them in the process and getting them through the door. By way of background, I am an attorney and I've worked with nonprofit organizations in the past, doing legal services work and including domestic violence and housing and social security. So I'm very familiar with I've also done matrimonial work and immigration. So I'm familiar with a lot of the issues that pop up with the users and consumers and clients that you have, that you're working with. So I think this is a great opportunity to just collaborate and, so that we have a mutual understanding of what we all do. So with that, I am going to share my contact information at the end. We do have a lot of information to cover. But I want Maddie to introduce herself, and then I'll start the presentation.
I'm sorry, Wendy,
Yes, Maddie, you're muted.
I didn't hear you clearly. What did you say?
If you can just introduce yourself and then I'll.
Okay, sure. I'm Matilde Sanchez. I'm a former prosecutor. I used to be a DA in Bronx County. I am an attorney, but in this office, I do not function as an attorney. I function as the administrator of this office, which has attorneys which do our legal work in surrogate court. I didn't have this type of background when I started, but I've become, I'm reading the law and making myself informed as to what it is. What I've done in the office is I've written the procedures with respect to the administration of the office. The actual legal rules that we follow are those already set out by the legislature, the court, etc. But anyway, this office has 5 employees. It's a very small office, 5 employees, a commissioner and a deputy, and what we call the decedent property agent, who is the person who goes out to these residences to do an investigation and ultimately is the one who's responsible for returning them if and when that's going to be done. So anyway, any questions you might have as we go along, happy to answer them.
So we do have a lot to cover. So I'm just going to give you an overview. So basically, we wanted to give you an understanding of the surrogate court procedures and what the role of the public administrator is, which I know is your great interest here. So we have a couple of objectives, and hopefully we can get through all of this. We do have about 90 minutes. So, if there's a pressing question, you can put it in the chat. We'll try and get to it. But we will have, as Tierra said, a robust Q&A towards the end. So we want to help everyone in understanding what we do in surrogate court. The name itself is a mystery to a lot of people, even people that I encounter in the court system. Many people know it as probate court, and so we'll talk about that. We're going to outline what the steps are for a petitioner to submit a voluntary administration, which is colloquially known as a small estate. And I'm going to be covering what to do when there is next of kin. And so I recognize that as the supportive housing network, many of your providers are going to be dealing with family members as well who may be able to step in and petition in our court. Maddie's going to be explaining the role of the public administrator, what to do when there is no next of kin, and I will be covering some of that as well, and how to work with her very small and busy staff. We're going to give you some tips and resources that we find helpful in moving cases along, and again, a Q&A. So what is surrogate court? So surrogate court, if you think of it, most people think of surrogate like surrogacy. And in fact, I had a very interesting applicant this morning who wanted to come in and secure the person's DNA, the sperm that they were leaving. So that was a first for me. And most people think of it as surrogacy, like someone is going to do an adoption. If you think about what we do, it's stepping into the shoes of the person who passed away in order to administer their property or assets. Okay, so that's what we're, our surrogate is designed to do. Our surrogate is Matilde Gonzalez, and she was elected to this position. And both Maddie and I are co-located within the Supreme Court building. There are many other courts here, so when people come in, they are a little confused as to where to go. But we are at 851 Grand Concourse, which is the main building in the surrogate's court on the 3rd floor. Each county has its own surrogate, and each county has its own jurisdiction. Oops, sorry about that. And we go back up. I was trying to move the people off my screen so I could see it. Let's see if I can minimize that. So each county has its own surrogate with jurisdiction to hear cases and to receive filings, and it's based on where the person resided at the time of death. Okay. So if someone resides in, passed away in Manhattan, but they were a resident of Queens, they would be filing in Queens County, the county of their actual residency. So we're going to go over some terms. There's a lot of things that you'll be hearing, and some of the terms are as follows. And these are all the people involved and all the terms that you'll hear. Decedent is obviously the person who died, but what I've come to know is not that obvious. A lot of people will put themselves down as the decedent because they're missing and putting that the word descendant as the person who did want to inherit. So it's important for you all to know the terms and also have your clients also be, and their families be familiar with the process so that they can get the forms in correctly. The surrogate is as I said, Matilde Gonzalez, and she is equivalent to the judge. She is a judge in our court, but we call her the surrogate. The petitioner is the person who's filing the application, and that's the person who's going to be managing the estate. And then we have the person who's actually submitting the application, and that's someone who's known as the fiduciary. The fiduciary is the person who's legally responsible and authorized by the court to manage those assets. Fiduciary can come under different types of names depending on what it is that they're trying to do. So, for example, you're probably most familiar with the word executor, and that's the person who's named in the last will and testament to carry out the estate responsibilities. When there is no will, the person is called an administrator, and that's a person who puts in an application and is qualified by the court, depending on certain factors that we'll get into, to handle the administration of the estate. And then for purposes of the smaller estates, we call that person a voluntary administrator, and that's for an estate less than $50,000. Other terms that you'll hear is a distributee. That's a person with a legal right to share in the estate, And you can think of it as the natural heir of the estate. Okay. As opposed to a beneficiary, who's a person who receives the property because it shouldn't say court help, but because of a legal arrangement or a document. Okay. If someone is a beneficiary, you can think of someone, let's say if you have a pension plan or an insurance policy and you name a beneficiary, that person doesn't need to come to court if that's all there is, because that falls outside of the estate. Or you can have a beneficiary under a will. And then you have designee, and sometimes we use a designee as someone to act on behalf of the estate. That person doesn't have to be next of kin, but a next of kin may ask that person to step in their shoes because for whatever reason they're not able to do it. So what's involved, other terms that you'll hear and what's involved in the proceeding is the estate itself. So what comprises the estate is any asset belonging to the decedent that hasn't passed through another way. So if someone has left an asset, like, as I said before, like an insurance policy, that passes outside of the estate. And then you have assets that are specifically entrusted to someone under a trust document. And the person, again, is a fiduciary who makes sure that that asset is held for the benefit of the trust instrument. When we talk about what compromises an estate, one of the first things we look at is what kind of asset is there. So we basically look at real property, and what that is home. It could be a lot of land, not like a bunch of land, but a lot, like an acre or a actual block and lot building, or a piece of land that they own. And also a condominium, because a condominium is the actual, you own that actual real property. Personal property, on the other hand, would be something in a bank account, monies at home, CDs, investments, a car, or a co-op apartment. And we get that a lot, especially in New York. There's so many different types of apartments. You have Mitchell Lama, you have HDFC apartments. But in a cooperative apartment, you own the shares, and that's similar to owning actual, having cash. And so we consider that the personal property. Another thing that people come to us is because they have a cause of action. There was a personal injury, a wrongful death lawsuit, and a family member needs to continue that cause of action and act as the representative. Remember, the person is coming in to step into the shoes of the person who wasn't able to complete that. They weren't able to settle the lawsuit. They weren't able to go to trial. So someone is stepping in the shoes to ensure that whatever settlement there is, it can still move forward. But what we don't do, because there's a lot of myths out there about what the surrogate court does do, but these are some of the things they don't do. We don't prepare wills for individuals, but we do keep a will on file for safekeeping. Someone can pay a fee to store the will in our office. So that's something that people do. It's not commonly known, but that's something that they can do. If they have to change the will, then they can ask for, to add some language to the will, then they can file and keep that for safekeeping as well. But they don't have to file a will. So a lot of people will come to us thinking that they want to search a will, but you don't have to file a will. You can keep a will in a safe place in your home. We don't hold any property that's taken from the petitioner. People will come here and say, well, I want my son's wallet. We don't hold any property. That is held by the property clerk's office. And we don't substitute a next of kin for someone who has a power of attorney. So someone who has a power of attorney is able to act on that person's behalf as far as financial situations is concerned while they are living, but not after death. So we don't, we look still for the next of kin to apply in our court. We also don't oversee healthcare proxy decisions. We don't do living wills or advanced care directives. although those seem like they're part of the estate plan, and they are part of an estate planning situation, we don't get involved in those issues regarding the healthcare decisions. Commonly, we get people who have familial disputes about where a person should be buried. And because this is a dispute between living parties, we don't get involved in that. We send those people to the Supreme Court so they can make an application to resolve that difference between the family members. The other thing is we don't oversee the management of an asset, as I said again repeatedly, where a beneficiary has been named. I'm having trouble seeing everyone. Can everyone see me? Okay.
Yes, we can see you.
Okay, great. So then just some of the laws in case there's some law geeks or attorneys or people just interested in looking at the statute. This is a statutory court. We do follow the Surrogate Court Procedures Act that lays out, what the rules are. We also follow the Estate Trust and Practice Law, the EPTL. We also follow the same rules as the Civil Law and Practice, the CPLR. So if there's someone who needs to be cited, we're going to be following those rules as well. The court, the surrogate court in each court has their own uniform rules, and that's part 207 of the uniform rules. And we do intersect a lot with other courts. So what I mean is that if someone has a lawsuit, we'll need to know what's going on in that action in the Supreme Court. Or you may have someone who needs to tell us that they can qualify, and they may need to get something from the criminal court. So there's some overlap with other courts as well. So the types of cases that we do, and this is how we categorize the cases. So I'll talk about the types of cases that we take in and what the person gets after they file. So we do probate. Again, that's what most is known. People hear it on TV. They want to know, they want to come for the reading of the will. There is no reading of the will. We will read the will when we see the application come in, but there's no formal, as you see on these television shows. But probate is when there's an actual will. If a person's estate is valued at over $50,000, they will file a petition to probate and then give us an original copy of the will. We have to see that will. We have to make sure that it passes muster, that it is something that the person properly signed and was witnessed. And as a result of putting in an application, which we see what the wishes of the decedent were, the person who's named the executor is going to get letters testamentary. For those people, and in the Bronx, we have a lot of people who do not have a will. If the assets are over $50,000, then they will file as an administrator of the estate. Again, it's a fiduciary responsibility. And at the end of that, they'll get letters of administration, and agencies such as yourself would recognize that person as a person with authority to do what is necessary. And we'll get into what those details are in a bit. A voluntary administration, which is really where a lot of your cases will come in, is colloquially known as a small estate. Those are estates that are valued at less than $50,000, regardless of whether the person had a will. And the outcome of that is that a person will get a certificate of voluntary administration. And I'll get into more details on that, because I know there's going to be a lot of questions about that. We also do guardianship. So we have a guardianship department, and we take in cases where maybe a parent or a sibling comes in and says, I have a developmentally disabled family member that's under age 18, or I have a family member who's intellectually disabled, and that person became disabled before the age of 22. And I'd like to help manage either the person to help go to the, make decisions, medical decisions, or help them manage their assets. So if someone died and left a will, there's going to be property that they manage. So particularly for those with property, those are the ones that we'll take in. We'll also take in a case where someone had maybe a traumatic brain injury and they're above the age of 22. We can also take that in. Well, just so you know, in the Supreme Court, there is a guardianship department that deals with people who have mental health issues, and that is under the umbrella of the Supreme Court. And we also do adoptions, and that's we have concurrent jurisdiction with the family court, and the result of that would be an order of adoption. So we're going to get into the steps of how to access an apartment that's been sealed by the police department. So just so that everyone knows, if someone passes away inside of their apartment and the police are called, and there's no one else living in that apartment that can show that they've been living with that person, the police are going to put a seal on that apartment. It's basically a sticker, which means that no one else should be getting access to that without first coming to the court and letting us know who they are, and that they have a right to enter that apartment. And we really take this seriously because we need to know that that person has an actual right to inherit whatever's in that apartment, to get access to that. So we have a lot of confusion around this. A lot of family members will come and they'll say, well, you know, I was the one that took care of the person, and I'm a sister, but I can't get a hold of the other family members. So I know that these are issues that you come up against as well, but we really need to go over who qualifies, and we'll get into that as well. So here is who can file. So again, when there's a will, the person who, when we look at the will, we'll see who's the executor, and that person should be the one submitting an application. If that person has passed away and an alternate executor is named, then we can have that person file. You can have a beneficiary file if the alternate executor is not available, or a distributee, someone who is inheriting. And our focus for this presentation, since most people won't have a will, is what do we look at when there is no will? So here's the order of priority, and this is statutory, so we have to follow this. We can't skip it because of what your presumed relationship was with the individual. So we'll look at the list, we'll look to see, the first thing we look at is, we ask you, is the original death certificate? And we look to see who's on it, who was the informant. We look at, to figure out, is there a spouse listed? If you've ever seen a death certificate, or if you look at one that comes in the future, what you can see is that there's a surviving spouse category. And so we'll look to see, because that person is going to have priority. So the priority is spouse first. If there's no spouse, a child can apply. If there's a spouse, but the spouse for some reason cannot apply, then they can renounce. That's on the third column. They can file a renunciation to give that to the child. And those are specific times where they can do that. So if there's no spouse, and let's say there was a child and the child passed away, we look to see if that child had a child. Was there a grandchild? Okay. So the clerks in our court will look at these steps to make sure that you're the right person to come in. If there's no spouse or child, and there were no grandchildren from a predeceased child, we look to see, are the parents living? And we look at both sides of the parents. So we will ask questions about a parent who might be absent. Then we look to see if they're siblings, nieces and nephews, aunts and uncles, down the line. We stop at cousins, and Maddie will be talking about that. So if there's someone who has priority on the third column over the person who's filing, the petitioner, they need to explain generally why that other person is not filing, or at least list them on the application so that we can give notice, so that they're aware that someone's putting forth an application on behalf of the decedent. Okay. So here, what we really wanted to focus on is why it's important to locate the closest living relative. And for all the reasons that I've discussed before and why people do a will is really to carry out the wishes of the decedent. Right? We don't want to not carry those wishes out if there is in fact a will. And also, if there is no will, we want to ensure compliance with the statute because we want to properly distribute those assets according to New York intestacy laws if there is no will. And that really is to ensure that heirs and distributees are not left out. Oftentimes there's discord amongst family members. And, you know, if we can say, well, this is how the statute says, this is how the distribution goes, then they understand that it's not that someone's taking over, but this is how the distribution is according to the law. And so it does, when I show them the intestacy tables, they can see that it's not that someone's trying to get a bigger piece of the pie of the estate. When we get in an application, we also look to see, does this person qualify to file? Because it's a big responsibility, and there are other factors beyond the small estate that we can get into, like personal injury actions and other things that a person may need to do, like sell a house. We look to see, you know, does this person qualify to do all of these things? The persons that are not eligible is a minor, an infant. This is reading right from the statute, so the language can be a little arcane, but it's a minor, someone who's not competent to carry out the responsibilities. And if you think about it, there might be times where a family member says, that person is not competent to carry out the estate, but I am. Or the court may determine this person is not capable of carrying out the responsibilities. Someone who is not a resident is also not qualified to apply, but they can designate someone. But if there's a foreign guardian, then that's someone that can actually apply or designate someone in the United States to apply for them. Then we have the category of felon. Under the statute, if you have 2 or more felonies, you will not qualify because it's a fiduciary role. It's a legal responsibility for carrying out the estates. But there are certain instances, if there's 1 felony, then you can get what's called a certificate from relief of disabilities. And that's when I said it was an intersection with the criminal court, and the person can tell us that they have been released from their this hold that was put on them to not take certain action because of their felony conviction. So we do look at that too, particularly in the estates that are above $50,000, where the question is directly on the application. And we also look to see who does not possess the qualifications required by fiduciary due to substance abuse and other things. They don't understand the process. They're incapable of understanding the process. And the court also in its discretion can say that a certain person is not qualified. So what do we use the small estate for? So when someone comes to our court, the relief they want is to get access to some type of account. So when they make their application, they're going to tell us what they're trying to do. So if they want a bank account, they'll tell us on the application that's what they want to do. And we'll issue certificates to those places so that they can be recognized as the individual. So if they know that there's, $1,000 in the bank account, they'll tell us that, and we'll give them a certificate so that the bank can recognize that person as the qualified person to do certain things with that money. So these are some of the examples. For your purposes, to obtain access and contents of an apartment sealed by the police department. We need to see who has those keys. So if, as a provider, you are holding on to those keys, we may need an affidavit from the family member stating that you have the keys. Otherwise, we look to see whether the police department is holding on the keys so that they can get into the apartment without, having to break the lock. So there are steps that we'll talk about that. again, assets with, we don't include in a small estate assets with living beneficiaries or assets that are jointly owned. So I talked about the beneficiaries, and if you're named, you can go directly to that, that entity. But if the assets are jointly owned, like a bank account between a husband and wife, the bank would then deal with directly with the spouse. If the assets are unknown, you still can get information. So there's a lot that can be done with a small estate to find out what this person owned. You can get information from the Social Security Administration. There's the New York State Comptroller's Office for Unclaimed Funds. If a person had a job a long time ago and there was a check that they never cashed, it'll go to the state comptroller's office. And it'll sit there until someone can claim it. And oftentimes a family member will look on their website, see that the person had some monies left behind, and then they come to us to ask to be, for a certificate so that they can claim it with the comptroller's office. And then they can also get information from a bank. If they don't know how much money's in the bank, we'll give them a certificate. The bank will tell them how much is there. In turn, they tell us, and we give them a certificate so they can properly collect that monies. You can also perform tasks. If you need to close a bank, let's say, a postal mailbox, you want to divert mail to someone else. You want to find out more about the medical records. Oftentimes, people have questions about how the person died. So they want to perhaps think about filing a lawsuit, but they need to see the medical records first. So oftentimes we'll get personal injury attorneys telling them come to court, and that's for the purpose of getting medical records so that they can see if there's a viable case. What is not allowed in a small estate is, again, to sell real property. Those are cases that involve administration. So you can't sell a house or a condo apartment. And you can't, again, pursue a cause of action. One of the key differences between an administrator above 50,000 and a voluntary administrator is that the administrator can get paid for their services. So if they paid costs to manage the estate, they can get reimbursed. If they happen to be the one who paid the funeral bill, obviously, as a creditor of that payment, they can get that monies back as well. So, Tiara, I'm not sure if this is a good time for questions on that before I move to what is needed. Please
Yeah, I think we certainly, well, I did want to do a time check. It's 3:10, and we want to make sure that we get to questions by at least 3:30, and we still want to have Maddie come on and talk about what her role is once things get out of the surrogate court into the public administrator. So yeah, I think it would be helpful if you just talk a little bit about when our providers could potentially get the death certificate, or like sort of what the process is when there is no next of kin, or the next of kin is unavailable. And then we'll want to get Maddie talking for a bit.
Yeah, she'll talk about that. So I'm just going to move forward on this, and then we'll get to those questions as well. Okay. So what's someone, and again, I'm covering the part of where there's a next of kin. What's always needed for us is an original death certificate. Where do you get that from? The funeral bill, the funeral parlor. So whoever paid the funeral bill will be the one that will be getting the death certificate. That is something that is the official document of someone who has passed away. So we need to see that. We don't accept a copy of it or a work copy. We do want to see the original death certificate. So you'll get that from the funeral parlor, or the family member will get that from the funeral parlor. We suggest that the family member get multiple copies, because we're going to keep that original, and we're not permitted to give that copy, even a copy, back to the family. For a small estate, the filing fee is $1. If there's a will, we ask for the original and a copy of the will. And if there's a property voucher that tells us what the police took, actually, we'll get that invoice. So oftentimes I'll call the police department and they'll send that over to me, or depending on the borough, they may just give it to the family member. But typically they will send it over to my office, and then I can see if there's any currency, is there any jewelry, anything that they may be holding on to. In some instances, if there is only one person who's claiming to be the distributee, the person to inherit, for instance, the person who died only had one child, we need to make sure that that's the case. A lot of people sort of get bothered by this, but we do explain that we need to make sure that no one's being left out, and someone who knew the individual for 10 years is gonna corroborate what the sole distributee is telling us. I'm just gonna skip renunciation because I talked about that before. For safe deposit boxes, some, especially older people, I've encountered this a lot in the Bronx, have opened up safe deposit boxes. Sometimes they'll open up a safe deposit box with a spouse, and then one of the family members passes away, or let's say the husband passes away, and the bank won't release that, even though there were two names on the account. So we have an application for that, to inspect the box and to see, is there a will in there? Is there a burial plot information in there that the person would need to carry out the funeral with, the wishes of how the person was going to be buried? If a child is born to someone who is not married at the time of their birth, we're going to need an affidavit showing that this person is in fact related to the decedent. And we'll ask for a birth certificate as well. I'm just going to click quickly on this website here, just to show you that there is a simplified application that you can guide your family members to. And this is a court help website. We have here a category says when someone dies. And if you go into small estate, it will bring you to this page, which describes pretty much what I'm telling you in this presentation. And then you can go on to the, to file for a small estate and go to this do-it-yourself program. And then here, it will bring you to the program. It takes about 15 minutes to fill out if you have the proper information, including names and addresses of individuals. And just to show you what it looks like real quick, you're just going to log in, agree, and then it's going to give you a series of questions. And it's run by Law Help Interactive here. So it's an easy, understandable program. It's in English and there's a translation in Spanish. And then it goes through a series of questions that at the end of this gives us the application that we're asking for. Okay. So after a person receives their certificates, what do they do with that? Well, they've already been determined to be the voluntary administrator of the estate. So if the certificate says that they can access the apartment, the family member will bring that certificate to your office, to whoever is managing the property for your network, for your providers, and they will allow them access into the apartment. If it's sealed by the police department, they'll have to arrange with the police department to get into the apartment, break the seal, and then turn over the keys or whatever it is, empty the apartment, whatever it is that is required of them on your end to do to turn the apartment back over. So they get one certificate for for each of the items that we described before, going into a bank, so that they can present it to those institutions. So they would give it to the bank or whomever it is that needs it. After that, if they find that there's more money in the bank, then they're going to need to tell us that by filing a one-page amendment telling us what it is that they have discovered. And if it goes over $50,000, we move on to administration if there's no will, and on to probate if there is a will. So their responsibilities are to open an estate account, deposit those monies into the account, and pay out any debt, sell property if necessary, pay out the administration expenses, pay the funeral creditor. If a family member paid and they want to get paid back and there's enough monies in the account to pay, then they're priority creditors. And then whatever's left over after paying that, they will distribute to the heirs, the distributees. They also will have to tell us that in a very simple form to tell us what happened to the money. And we give them between 7 and 9 months to tell us about that. And again, the Help Center is here to help people understand that, because after some time, you know, they forget, or they may not be able to process that when they come to our office. But they are, and they do remain accountable for the administration. It doesn't mean that they're paying debt out of their pocket, but it does mean that they're accountable for how that money is spent out. Okay. So, I mean, I guess it's a good time to pause for questions for me, or we can go to the public administrator.
Yeah, so I'm just making sure to ask folks to put their questions in the chat so we can compile them. But yeah, I think if you want to go ahead and pass it along to Maddie, that would be perfect.
Okay, so do I have to? So Maddie, I'm going to see. I think I lost the picture here.
We can still see your screen.
Should I share it back to you, Kiara?
You do whatever you can, obviously. I just have a very simple explanation of what it is. So let me know when you're ready and I'll take over.
Yeah, sure. Yeah, Wendy, if you want to stop sharing, you can stop, and then I can.
That's better, because I couldn't see the faces, and that was a little, I felt like I was talking to myself.
Thank you so much. Please remember, put your questions in the chat. If you have specific questions about your experiences, please put them in the chat. We'll try to get to all of them. And then, yeah, Maddie, I'll go ahead and pass it off to you, so you can talk a little bit about what happens if there is no next of kin who's going to be the voluntary administrator of the estate.
Okay, hi. I want to thank all of you for giving me this opportunity to be able to explain to you what the public administrator is and what they do. You see, nobody has any clue what the public administrator is. They don't even know that it exists, you know. So I think it's important, once you know what our function is, we'll be able to work together. And it's extremely important that we do for the benefit of the people of the city of New York. And in my case, particularly the city of the Bronx, the people of the Bronx. Anyway, first of all, Wendy just explained to you the situation of what is the surrogate court. Surrogate court is a court, obviously, law, they decide cases, they do all sorts of things that we don't do. The public administrator is a city agency. We're not a court agency, it's a city agency. And we follow the rules and the law from the surrogate court. So we have to follow those rules, but we are a city agency. Now, as a city agency, while we're subject to this, the Surrogate Court Procedures Act and all those other laws, we have to abide. We have no choice. Okay, so city agencies or city people who work for the city or do work for the city, we have no choice. We cannot just break those rules and follow other rules. We have to do exactly what the law mandates with respect to surrogate court. Now, I'm going to give you a simple explanation that I give to everybody who comes in here, and maybe it explains to you exactly what the surrogate court, what the public administrator does. What I say to everybody is that when someone dies who is a resident of the Bronx County, whatever they leave at the time of their death is their estate. Even if it's just a pen, that's their estate. Somebody has to decide what to do with that. And it can't just be the landlord who says, let me throw the pen away or whatever. Somebody who has the power to decide can decide. Now, Wendy just explained to you who can have the power and what they have to do to get that power. And if you don't have that power, you can't decide what happens to that penny. Okay? So what happens is basically when someone dies, they can go to the surrogate court and get that permission. And Wendy told you who could do that. But unfortunately, landlords don't have that right because they're not related. They're not part of that list that Wendy gave you. So what does a landlord have to do to be able to get done what they need to get done? I think that's the basic question here. And what do they have to file in court, if that, to be able to have the authority to get rid of the pen, or in your case, to take back the apartment, okay, or whatever. So what happens is, what happens is when someone dies and they die in their residence, the police is called. The police goes in there. They do what they have to do because they have to make sure that there wasn't foul play. They do what they have to do, and then they will collect certain things from that apartment. If they see anything of value, they will collect it. Sometimes they collect the keys to the apartment, sometimes a cell phone, or if they see money or something of value, they take it, they voucher it, they take it to the police department. Then when they leave that apartment, by law, they must seal it. Why must they seal that apartment? Because they got to make sure that they protect whatever is in there for the heirs. Because anybody else can just walk in there, right? Take whatever they want. So that apartment is sealed by the police with a green seal that says do not enter. Now, who can enter? Who can break that seal? Well, as Wendy explained to you, there's a list of people who could break that seal only if they get permission from the court. They got to go to court, apply. If the court gives them the permission, they can break the seal. If there is no one available to get that permission, the public administrator can break the seal. We have to open up an estate, and then my investigator goes out, breaks the seal, goes in, and there's a purpose for going in, a reason. The investigator goes in to see if they can find out who the heirs are, because the reason we're going in there is because nobody knows who the heirs are and nobody was able to go to court to get permission. So they're going to look for a phone book that maybe somebody had, or a cell phone that may have phone numbers in it, or maybe a Christmas card that has return address from a relative. Anybody that can help us find heirs. Then also they have to look for documents that will tell us what, if any, assets other than that pen they may have had. Did they have a bank account? Did they have shares in this building that they live in? Do they have a car? Is there any information there relating to the car? Do they have a pension with NYSERS or anybody? So all of that information, they're experts at gathering to bring back to the office to help us find the assets. They also will contact the police department and find out if the police department vouchered any personal property belonging to that person. And if the police department vouchered it, our investigator goes down there, picks up that property, brings it back to the office. It's placed in the safe for safekeeping. Now, once our investigators finish their investigation, what they must do is they also seal the apartment. By law, they have to put a seal on that apartment. Why? Again, to protect heirs. You don't want anybody just walking in there and taking whatever they want. So our investigators remove the green seal and place a white seal on the door. Now, your landlords have to look at that seal and see who placed it. If it was placed by the police department, that's not a case that I have. It's not a case that I have authority over. But if it's got a white seal, you can call here, it's our case, and we can work with you returning that apartment. Okay, so that's extremely important for your landlords to know that. What seal is on that door? And then that way we can start working. Now, problem is, most of the time, your landlord wants something, it's the green seal there, and they want their apartment back. I don't have the authority to do that. Your landlord is going to have to go to court and ask the court for permission to enter that apartment. And the court will probably say, you don't have the authority because you're just the landlord. We have to find the heirs. So the court will say, public administrator, I'm going to give you this case. You open it, you do what you have to do, and return the apartment if you have to. That's how it works. That's just the most simplistic way that I can explain to you what our function is and how we do it. Our, our investigators try very hard to work with the landlords, and I tell everybody this. My dad was a landlord. He owned a building, and he had this problem all the time. So my heart bleeds for landlords. I want to help them. I want to find an easier mechanism. I don't have it because I don't have the legal authority. But if you give me the legal authority, I can help you out. Now that's one thing. The other thing is, if we don't have assets, if the person who died doesn't have assets, there's nothing for me to do, because our job is to collect assets. We are a collection agency. We get all of these assets, open up a bank account in the name of the decedent. So it'll be the estate of so-and-so. All monies, anything that we collect, we find jewelry in the apartment, we get it appraised, we auction it, that money goes into that account. We sell the car at auction, goes in that account. We collect money from a bank account, goes in that account. All of those funds go in that account, and then that money has to be distributed among the heirs if we can find them. If we can't find them, the money goes to unclaimed funds after things are, whatever debt is paid for. So that's really the situation that we find ourselves. How can landlords, and in particular, landlords in your situation, how can you get the authority to ask the court, or, how do you get to the court to get them to give you the authority to ask me, or for the court to give you the authority? The landlord can't give me the authority. Only the court can give me the authority. So the landlord has to ask the court to get me involved. Happens all the time, by the way. And the only problem that you will have is that to be able to file that in court, you're going to need a death certificate. And usually landlords don't have death certificates. The body is taken and they don't hear from anybody else, and they don't know if the person even died. We had a case where we didn't know the person, the landlord said the person died. We tried to help, this was years ago. And what happened is, the person was not dead. We're administering an estate where the person's dead. Not dead. We need a death certificate. Landlords can get a death certificate. They get it through vital records. We can help you in showing you how that's done. But the landlord has to get a death certificate so we know the person's really dead, and then go through surrogate court to get permission to ask us to continue the administration. I hope that explains what this is about, and if you have any questions, I'm happy to answer them.
Thank you so much, Maddie. That was really helpful. Thank you so much, Wendy, for giving us the overview of the process. There are some questions in the chat, but I will open it up to the floor to see if anyone wants to ask their question live. Okay, we have Dr. Dion Pendleton. Hi, Dion. Can you just introduce yourself, your name, organization, and go ahead and ask your question?
Hi, everyone. I am Dr. Dion Pendleton. I'm the program director of 5 unlicensed OMH programs for the Jewish Board in the Bronx. We have scattered site housing in the Bronx. We also have some in Harlem, but one particular situation, we recently in June we have a 2-bedroom apartment in the Bronx. The resident died inside the actual apartment that is leased by us, the Jewish Board. And then the Jewish Board pays the landlord. So with that being said, when that individual died, we had NYPD come, EMS removed the body, NYPD sealed the apartment due to the fact the roommate was not in the apartment. The roommate was in rehab. So as it stands, the apartment is still sealed. And in the past, when we had this happen before, we call NYPD, ask them, can we now have access to the apartment? Is the investigation concluded? They will either say yes or no. 9 out of 10, they tell us yes. And yes, we can remove the seal. And then we go in there and do our function of postmortem cleaning. We notify the residents next to kin if they had any. And we do all of those steps. But in this particular incident, we're now being denied or kind of getting a runaround of saying NYPD is not giving us the access to the apartment. And I got to keep waiting to speak to the detective that was on the case in order for them to tell me yes or no. So my question is, why is this happening when it hasn't happened in the past? And when I say the past, I would just say like 2 months prior to June.
Okay, I can give you an explanation unless Wendy, you want to explain. I'm going to tell you, first of all, NYPD does not have the authority to tell you to enter that apartment. They can't. Because while the apartment may be yours and belong to your agency, the contents in that apartment belong to the decedent and his heirs. So to allow anybody in there is not something that the law allows. So the NYPD should be sending you to surrogate court or to the PA to ask how they could do that. If they give you access to that apartment, they're violating the law.
So I think that Dr. Dion was also referring to that there's a roommate in this case, and the roommate is now, because they were in rehab, now outside of their living quarters. They can't return to that particular unit. What I've seen them do is if someone is there to say that the apartment belongs to 2 people unrelated, that they only seal that bedroom. I've seen that happen, and then the person has access to the remainder of the apartment. But I guess because the person was in rehab, if there was no one there to say that that was the case, because usually the NYPD will say, who else lives here? And they won't seal it if there's someone else in the home at that time. In this case, they're not going to be looking at leases. They're not going to be making a determination, and they also don't want to be held liable for allowing someone to go into the apartment that shouldn't be. But in the instance that the person who died away does have some next of kin, family members, they need to step forward. They need to come forward and to make the application so that, and if that's not possible, then we would be sending that person to the public administrator as needed, and they would make their determination about when they can go in. But I think that's, it's a situation, I think if the tenant had been there, that probably wouldn't have happened. But of course, we can't predict what, somebody might be on vacation and they come back and their home is sealed. So that happens quite frequently, but the police department is not going to take it upon themselves to say, he had a girlfriend that lived there with him and she has her belongings there. And we get that a lot. We still need to, as trivial as it may seem, we still need to protect the assets of that individual. And that's kind of the quandary that we find ourselves in. And it frustrates a lot of people. People, are put out, but that's sort of, unfortunately, the reality of some of the situations we find ourselves in.
Where there's a roommate, we don't have the authority to go in there. Why? Because we don't know what in there belongs to the roommate and what belongs to the deceased.
So one of the caveats, just on the topic of the police department, is that, if someone has passed away, they have to do their investigation. And oftentimes it's not accessible, and I think maybe even to the public administrator, because the investigation is ongoing. They may be
True.
needing to protect evidence that is in the apartment, depending on the circumstances under which that person passed away. So I will contact the NYPD and I will get a property invoice, which tells us the items that they collected. And in some instances, they may not even be able to turn the item over. If it's a phone, a piece of clothing, sometimes you'll see on the invoice, it says, under investigation, which means that I can't have that family, I can't issue a certificate to have that family receive that property from the police department because it's evidence. And sometimes jewelry could be evidence, a phone could be evidence, and they won't turn that over. So there's a lot of other dynamics at play as to, why some of these things happen.
Thanks. Thanks so much, Wendy, Maddie, and thanks, Anne, for asking your question. Does anyone else want to ask a question live? And then I do want to acknowledge what Sydney put in the chat, that we do have someone from the Staten Island Public Administrator's Office on the line too.
Yeah, I put my question, this is Jacqueline Bausch from Urban Pathways, and I put my question in the chat, but I just wanted to raise it. What we find is that we often have clients who do not have family members, and our program people do not know who their next of kin is. So unfortunately, we cannot go the usual route. We're aware that they died. Often the apartment is sealed. And what we would like to be able to do is go directly to the public administrator and inform them there's a client who has died and there's no known next of kin, at least from our perspective, and get that kicked off rather than, I think the court proceeding you were referring to is a proceeding to get back possession of the apartment, which I understand that, but it seems like it could be time consuming and potentially slow things down. We're happy to work with the public administrator and let them do their work, but that's really my question, because it comes off pretty frequently that we have clients who do not have any known next of kin, and we want to get the property to the public administrator and then get the apartment back available to clients that would need it.
Yeah, I appreciate the question. Sorry, I can't see your last name, Baus, Jacqueline Baus. But I think one of the things that we were brainstorming about when we had this prep call is some of the things going forward that can be done by the providers. Because I understand that everyone has a case manager, I think just maybe at intake or at some point, teasing out that information about the family member, particularly during this critical time of COVID, where people are going into hospitals and not able to return or whatever the case may be. Unfortunately, we've seen such a spike in cases. And I know you are proactive on these things, but encouraging people, even as an exercise, and if you have case managers, an exercise for your family members, who can we rely on in the event of an emergency, things like that. We often find when people walk through the door and they tell me, I'm a friend and there was no family member. We need to dig a little deeper, and I know you've probably done this, but I often find that there's a reluctance to share information as opposed to that there's actually no family member available. And so when we explain the process and who has a right to the apartment or to whatever asset there is, people do start coming up with names and numbers and information. Oh, I remember, someone, attended a wedding or came to visit the nursing home or whatever the case may be. Or I have a guest book and they came to register, because I know some of your housing has, people sign in and out. And those are sources that I think is important for us to have and for the public administrator to know about, so that they have some leads, because they have to start somewhere. And I think that a lot of it is, it's not that people don't have next of kin, but that the pain and the everything that goes along with the death and the old family, issues that arise, people don't, have buried those, so to speak, buried, but that they have put those relationships aside and they don't want to reopen them. So as difficult as it is, I find that when I have conversations with family members, they do end up getting someone who can come forward, or at the very least tell the public administrator, we give consent for you to take the case over.
Wendy, could you talk quickly about the waiver or the affidavit that you had mentioned to us before? If someone has known someone for a particular amount of years, I think it was 10.
Before you go
ahead.
I think we're talking about the affidavit of heirship.
Okay.
That's part of the application when there's a sole distributee, just to confirm that in fact there's no other people that are being left out of it. So there's one child, but they're estranged from the brother and they don't want the brother to know that they're filing this. We need someone to corroborate their story. I think when we had the prep, there was a conversation about something that they would file with the PA's office. So I'll let Maddie answer that.
Jacqueline, the question that you asked is a great question. And it really needs it's really a very simple explanation here. When someone dies and there are no relatives at all, that body goes to the morgue, the ME. The ME they have their own investigators and their whole investigation system, and they look for family. They actually look for family, and if they find family, the family's contacted, and what happens at that point is the family will bury. And once the family is buried, that's the end of their involvement. What happens is when the ME gets these bodies and there is no family and nobody claims it, that is a report of death that is sent to the public administrator. We open most of those cases because there's no family. We know that they already investigated, they found no one, and now it's our job. And that they give us an address, and that's when the investigator goes out to that address, and that's where you're gonna see the white seal. Most of these cases that we have come from the ME, because there's no family. Okay, your problem is when there is family, the ME calls the family picks up the body, buries it. We never get the case. So we don't know anything about it until you tell us that there's an apartment that needs to be opened, that needs to be returned. That's the problem.
So I think we had, I had shared this PowerPoint presentation, and one of the things was who can report, who can do the report of death, and that includes a member of the community as well. Maddie, if you can speak to that.
Yeah, well, anybody can make a report of the death of a person, but to make a report about the death of a person, they have to have a death certificate to prove that that person's really dead, number one. And beyond that, we look to see what what the next steps are. If there's actually, we will look, in many cases, we'll check to see if we can find family. We have computer programs that help us locate. And if we find families, we can't do anything. We can't usurp a family's rights. So we have to step aside. Right. Well, also what we do, if your landlord calls us, we contact the medical examiner to find out who claimed the body. If the body was claimed, we call them and they will tell us, oh, son picked it up, daughter picked it up, sister picked it up. Then we know we can't proceed with that because there's a family member who has priority over us. That's what happens.
Thanks so much, Maddie. So I just want to clarify, there was a question in the chat about the seal and about the communication between the NYPD and the Public Administrator's Office. And it seems that, Maddie, correct me if I'm wrong, but the police will put a green seal on the door if they have sealed it. And then the public administrator, once the investigator has come out, they will then put a white seal on the door.
Correct.
So you should be able to tell by the color of the seal on the door who actually has jurisdiction
Right.
over,
Once there's a white seal on that door, you call here. And if we had to turn the case over to a family member, we do that. But generally speaking, that's not the case. And then we release the apartment at some point. I generally make them hold on to it for at least a month because we're trying to find family. It may be that, you know, they haven't talked to mom in 3 weeks. They didn't know mom passed. And we don't want to, you know, turn over the apartment, and they want to know what happened to all of mom's photographs or all of her heirlooms, you know. So at least we try to give it a month once it's our case. And then we work with the landlord to get the apartments back. And we make them sign, we give them a release, we sign it. We have a, by the way, we also change the locks on the door to protect what's inside that apartment. So we'll change, if somebody has a key, we'll change that lock to make sure nobody enters it.
excellent. Deanne, you had your hand raised again?
Yeah, so just to make sure I am understanding,
Mhm.
let's just say that there is an individual that dies in the apartment. There is a nephew that is I would say the next of kin. That individual will trump your department, and they will then have to go to Cerrachio court, file their petition to become, I don't know, the executive of the estate.
Administrative,
And
yes. Mhm.
And then once they become the executive of the estate, they then should be notifying the non-for-profit organization that is the leaseholder of the apartment.
Right, correct. They don't all do that.
I'm sorry?
They don't all do that. That's your problem. They walk away from it because they think you're going to ask them for rent in some cases. So they walk away from it. So now you got somebody who should be in charge of it, walks away from it. What do? You now have to go to court and ask the court and let the court know, hey, we tried and this person's not helping. Please get the public administrator involved.
So when you say go to court, that's you at 851 Grand
Not
Concourse, third
me,
floor?
I'm a city agency. That's
Okay.
Wendy.
Wendy.
Put the link in for our forms. So I know the most of you providers have counsel. It might be something that you would have asked your counsel. You know, who's going to be the one to submit this application to request that the public administrator be appointed to handle the estate, to administer the estate. So that is an application. The forms are there. I'll put my the PowerPoint up again with our contact information before we end, just to make sure you have it. If you have a question about what forms, you know, that's where you want to start. We have a lot of information on our website that tells you what you need to do. So again, if you have legal counsel, ask them, what is our protocol? Who is going to be submitting the application? Is it a director, someone else, to request the appointment of the public administrator? The forms are fairly simple, telling us who you are, who the decedent was, as much information as you can, and what you're trying to do, and that you're asking for the appointment of that person. Again, the court is still going to want to be satisfied that there are no family members whose rights are going to be stepped on. And if you think about your own family situations, and sadly, you know, we've all had, many of us have had losses, including myself, who, you know, you're kind of stuck. You know, you don't want someone else's, you know, rights to be stepped over. Sometimes people just don't even, they're not in contact, but there's an inheritance that they're entitled to. And then many times they come forward at the point of knowing that there's something of value. I know that many of your, the people living in your supportive housing don't have means, but there are other things that they may have had prior to coming in, including pensions or other things that you may not even be aware of. So we do, step cautiously on, on these rights. So it seems harsh, and I get that, but it's, we do have to follow the statutory rules. If there's a workaround or if there's legislation that people want to work on, I'm sure that that's something that's going to raise a discussion. And here comes Ron. If you need to add anything, Ron, Ron is our chief clerk in Staten Island, who does a great job out there. Out in Staten Island, there are a lot of police officers and teachers and people with homes and a lot of things going on out there as well. Ron?
Thank you, Wendy, and thank you, Sydney. This is really, really very informative. What a network you created here, and I've been listening and learning. I've been doing this in Surrogates Court for over 30 years, and no matter how much you think you have it down, you learn something new every time you have an opportunity to exchange ideas and thoughts and scenarios. We just got a call, and the person obviously will remain anonymous. She's one of the she's from our court family. She works in Queens, and similar circumstances to what you're challenged with. But I was wondering how the Bronx would handle a specific situation, or have you had a specific situation like this? A child, a non-marital child, small estate. Unfortunately, she doesn't have the necessary documentary evidence in the form of acknowledgement of paternity or a proof of affiliation or an order from a court. She has a birth certificate, but she was born prior to when hospitals recognized the birth father and had them sign an acknowledgement of paternity. She does not have a DNA marker test or a DNA test or a genetic marker test. So she's kind of out there, and she wants to recover her dad's contents of an apartment. The decedent had siblings, but they don't seem interested in getting involved at this point. So would you, A, send her to the public administrator, because she did pay the funeral expenses, so she comes in as quote unquote some type of creditor, or B, would you just tell her that she couldn't do it and that the next of kin would be her brother, the brothers and sisters of the decedent? These are always challenging questions, especially when you have a small estate. There's not a lot of money, but you want to make sure you do as best as you could for the family who lost a loved one.
Right. I think that this is a scenario that I'm sure plays out in all of the providers here. I think it's not an unusual situation. I would say that those brothers and sisters that were actually acknowledged should be the ones to come forward and make the application instead of getting involved in whether this child was legitimized or not. I mean, if they want to share in the estate, we're not getting in the middle of that. But I think that if you have a secure person who's going to be who is the next of kin without any issue, well, why aren't they the ones to administer the estate? And at least in my opinion, if the situation were such that she can't prove that she's the child, I mean, maybe the judge would take, and your judge as well, would take secondary evidence or have a hearing on it. I think
how about, one of the suggestions by members of our court, which I thought was quite good. How about the brothers and sisters, if they sign against their interests and they say, give a brief statement that, yeah, decedent X openly and notoriously held themselves out as the parent, and we understand by signing this document that we will not share in the estate of.
I mean, or they could simply administer it and then decide how to
work on the side. Just work, yeah, because I did ask her, are you friendly with your brothers and sisters? And do you have the brothers and sisters of the decedent, and you have a good relationship? If you do, then they could do this on her behalf. And then, like you said, when it comes time to get the apartment contents or to receive any of the other assets.
Yeah, I think the question is, and that's why, I don't mind receiving calls and emails. I prefer emails, but receiving the calls to clarify if there's someone who can do this estate cleanly, by all means, let's get that person in first. In a situation where she was a non-marital child and she can't prove it, she's gonna, maybe have to
Yeah.
find an attorney.
But I can see the public administrators' hesitancy here. You do have family members. It's not like a situation where they're held out at the last recourse, where there's no family members and they have to take the position to administer the estate. But there are living individuals who could indicate that they are an heir of the decedent and come forward. So again, I just want to thank all of you for expressing some of the difficulties you deal with on a daily basis, and really re-educating myself, and Wendy, you did a fabulous job indicating to these ladies and gentlemen of all the different things that are out there and available.
Thank you. Thank you so much. Thank you so much, Ron. And yes, please kudos to Sydney for all of her work and pulling all of you together. We really, really appreciate it. I do want to do a quick time check. It's 3:58 and I want to be mindful of everyone's time. And I do just have a couple more quick questions for Maddie.
Yeah, if you could just quickly give me permission to share, and I'll keep our contact information on the screen while we're talking.
Sure, we could do that. You still have permission to share. And Sydney also put it all in the chat too. So she put a document that says sealed unit contacts, and that's the contact information for all of the county public administrators. But thank you so much for sharing, Wendy. There's that information. So Maddie, just a couple quick questions about the timeline for, say a unit has already been turned over to the public administrator, there's a white seal on the unit. What is the turnaround from when you receive information and when your investigation is complete? I'm asking, I think on behalf of some of our providers here who have had units sealed for, 6 months,
Okay.
8 months or more.
We put a very, very high priority on going out and doing investigations, because we're afraid somebody will go in there and do something. So therefore, the minute we get that a notification from the ME, we immediately write out a memo for our investigators to go out, and they go out the next day. The next day or the day after that, if they have too many cases, but they go out immediately. So, but those are only cases that we have. Most of the problems that you guys have is that we don't have your cases. It would be very simple if we had it, and we could move forward, but we don't generally have your cases. That's the problem. And then we get called, give us back this apartment. We don't have the authority to give back the apartment. It's not our case. Okay, but our investigators go out right away. And once they go out and do what they have to do, we try to return those apartments within 30 days. It gives us time to find heirs, but within 30 days, we're looking to give that apartment back.
Thank you. So there's a couple of other questions in the chat about what to do if there is a next of kin who doesn't actually want to be involved. So
Okay.
could they get a notarized letter to you?
Okay, that's a good question. Next of kin who doesn't want to be involved gives us a waiver. It is a legal waiver that we give to our attorney. Remember, our attorney has to file legal documents in court. Can't file anything there that's inaccurate. Our attorney has to have the waiver from those people that says, okay, you can do it for me. And therefore, that's part of what we give them. It's a form. They just fill it out and they give it to us. And it's very common. We use that here a lot.
Does it have to be notarized at all?
Yes.
It has to be notarized.
Yeah. Because our attorney relies on the information that we get from the public. And so therefore, the attorney has to know that somebody is verifying that that's truthful.
And can we get the waiver via the website, the Bronx County PA website, or is that a waiver that they would have to communicate with you in order to receive?
There may be one on the website, I'm not sure, but if there isn't, we can put it on the website. And,
Maddie, could you send us the waiver and then we can send it around when we do our
okay,
follow-up?
what, we could do that. Remember, it can't be, and if there are 5 kids, I need 5 waivers.
Okay. Mm-hmm, mm-hmm,
I mean, or 5 kids, everybody's on the same level, right?
mm-hmm.
So I would need the 5
You
waivers.
would need a waiver from anyone on that priority list that Wendy
Right,
mentioned earlier, right?
exactly.
Anyone on that order of priority.
Right,
So
exactly.
I just want to acknowledge, I know some folks are hopping off and we're a little bit over time. I'm happy to give a couple of more minutes if that's okay.
Sure.
To be mindful of your time too. In the chat, there are several things. One is a survey for all of your sealed units. We sent this out to some folks before. If you could complete that survey and then indicate on that survey whether or not your unit is sealed by a green seal or a white seal, I think that would be really helpful. Again, Sydney shared the contact information for all of the surrogate court and PA's offices in the chat with a couple of more links, including I think this the form, Sydney, the waiver?
Yeah, I just wanted to hop in to ask Matilda really quickly. I went to your website. It says waiver of citation, renunciation, and consent to appointment of administrator. Is
Okay.
that the waiver that you're looking for?
Yes.
Okay,
Very
perfect.
good.
I'll just show everyone right here. This is right what Sydney is talking about. Perfect. And then it sounds like that is the document that most of you who are experiencing a situation where the next of kin doesn't want to get involved, or perhaps has been unresponsive for a certain amount of time and maybe just wants to be done with it, you would submit that form. I'm assuming they would have to get it notarized and then mail the original copy into Maddie at the address that we mentioned earlier. We do have all of the questions that came in the chat. And so we are working on pulling together some sort of document that will give you, links to all of these forms, the contact information, and some additional just basic questions, including some of the ones that are asked in the chat. I want to thank you again, Wendy.
Before you go,
Maddie,
just
Ron.
one quick
Yeah.
thing. Remember, if you're giving me a waiver, I need a death certificate to verify the person's dead, right? And then a report of death. The report of death is on the website. Just fill it out because we need all of that information. But the death certificate, very important.
Yep. And Maddie, you mentioned that folks as landlords who maybe otherwise would not have access to the death certificate can, in some instances, get the death certificate through vital records, and they can communicate with you or contact you to learn about that.
Well, the landlords can get the death certificate from the Department of Vital Records.
Mm-hmm.
In the past, this office would, I think, charge $50 to a landlord, and then we'd order it, get the death, because we got it easier, get the death certificate, give it to the landlord, and then, they would move that way. But you guys can get it. You don't need us to be able to get the DC.
Yeah, when you're asking for a death certificate from the Bureau of Vital Records, so you have to pay a fee, and they want to know why you should get it. Are you the spouse? Are you the child? And there's a section there, and I'm not sure how many people pay attention to it, but it says if you have a legal issue, you can get it. So that might be something that you might have to deal with the Department of Vital Records to show why you need this.
Right.
So it's another hurdle. We apologize for all the hurdles. Just to put things into context, we were closed during COVID, but our staff was still working, whether remotely and coming into the office. But for the Bronx specifically, we started pre-COVID with about 44 staff, and we're down to 29 as a result of people having retired during this time and leaving for other jobs and whatnot. So we have been working with the staff that we have. I know Maddie has also faced similar challenges with her staffing, and we try and do the best we can. And having this roundtable here is great because you now know how to get things into us so that at least past first muster with those that have families and those that don't, how to reach Maddie. So I do appreciate you, Sydney and Tiara, for organizing this again.
I just wanted to thank again the Honorable Matilde Sanchez. I didn't recognize you, the
Hi,
administrator. You were phenomenal. You did a wonderful job. Thank you very much. I know the folks here must really appreciate your participation and effort.
thank you.
Dion had her hand raised, so I'll just give her a quick second for that, and then we'll let you all go, and we'll absolutely be in touch with a lot of follow-up information.
And we're here available. You need us, call us. We'll help in any way we can.
Matilda, I just had a quick question. You said
Sure.
you needed the death certificate, and what was the other form you mentioned?
Report of death. A report of death is a form that we have on the website that it gives the pertinent information, and then it's notarized. Remember, our attorney needs to know that it's notarized. So you make a copy of it, fill it in, and then notarize it and give it to us.
So you need the death certificate.
With the waiver, the DC.
The waiver and the report of death.
Report of death, perfect.
The courthouse is open for notaries. There's free notary up to 5 documents in the main floor of our courthouse. So for those family members, I recognize a lot of people don't have the monies to make copies. To the extent that you can help them with that, for those that do have families coming forward, when we get applications in that are, completed properly, and I don't have to make 6 phone calls to correct it, or send them back 3 or 4 times to make sure that it's properly notarized. It really goes a long way in getting that turnaround time down. So that would be very helpful.
Excellent, excellent. All right, we are 8 minutes over time. I appreciate all of you staying with us. Thank you one more time to Wendy, Maddie, Sydney, Ron. Thank you so much for joining. Thanks everyone. We will be in touch via email. Please be on the lookout. Don't forget to fill out that survey because we can then submit that information to Wendy and Maddie, and they can review the units that are currently sealed and help us figure out where in the process those units are, or whether or not they have jurisdiction, and perhaps what you need to do to move forward on unsealing those units.
Great. Thank you.
Okay, thanks everybody.
Nice
Bye.
meeting all of you. Thanks. Bye.
Thank you.